Thank you, everyone. Thank you, everybody, for coming. My name is José Montelongo. I am the head of collection development and Mexican Studies librarian at the Benson Latin American Collection across campus. I want to thank Steve and Danielle for this program that even before it started, you can see how much work it went into it, and then all the communications, just the hundreds of emails by Danielle to everybody. Thank you both. A few months ago, when Steve told me about the topic of this Flare Symposium, he said, we don't want to lecture anybody, to teach anybody anything. We're here to learn. We want to listen. We want to be part of the conversation, but mainly we want to learn. And so in other institutions here on campus, we sympathize with that. That's also why we're here. We want to learn. We want to have time to slow down for a second, for a moment, for a couple of days, and think about these issues, because there's usually such inertia and overdrive that there's no time to think these very, very important questions. So thank you all for coming, especially those of you who come from out of town. Thank you for spending a couple of days with us and being part of this conversation. You'll see that it's only two speakers with us today. Sarah Sonner from the Briscoe Center of American History, also here at UT, couldn't make it. She's sick and she wishes she could have been here with us. Next time, there will be a next time. So with that, I'll just say that our speakers are going to talk for 15 minutes instead of 12 like the other panelists.
Or maybe
and
20.
Maybe
20 minutes.
It might be even
50.
But we could also finish the panel a little early.
Or not.
Yes.
Good.
This panel is with two lawyers, so we might go.
Yeah,
we might
good
also
luck.
go long.
Yeah.
I will introduce Shannon first. Shannon Keller O'Loughlin is Executive Director and Attorney of the Association on American Indian Affairs and is a citizen of the Choctaw Nation of Oklahoma. Shannon was the former Chief of Staff to the National Indian Gaming Commission, where she assisted in the development and implementation of national policy throughout the agency and oversaw the agency's public affairs, technology, compliance, and finance divisions. She has also served Indian country in the private sector as an attorney, leading a national firm's Indian law practice group and bringing more than 18 years of Indian country legal and policy work to strengthen, maintain, and protect Indian nation sovereignty, self-determination, and culture. She was appointed by Secretary of the Department of the Interior, Sally Jewell, to the Native American Graves Protection and Repatriation Act Review Committee in 2013, and continues to serve under her appointment from President Barack Obama to the Cultural Property Advisory Committee within the State Department's overseeing the 1970 UN Convention on the Means of Prohibiting and Preventing the Illicit Import, Export, and Transfer of Ownership of Cultural Property. She's going to talk to us about advocating for our ancestors, repatriation of Native American cultural heritage in the United States.
Oh, I'm going first?
Yes.
I guess I'm going first. Okay, let's go then. All right.
Great.
Well. Good afternoon, everyone. All right, let's see how this setup is working here. Okay, before we get going, first, thank you for your time and your patience, and I will welcome questions after we get done speaking today. But before I get started, I want to first recognize the peoples who are the original inhabitants of the place we stand today, that we occupy today. There are federally recognized tribes in the state of Texas that include the Alabama Coshada tribe, the Kickapoo traditional tribe, and Isleta del Sur Pueblo. And there are state-recognized tribes that include the Lipan Apache tribe and the Texas Band of Yaqui Indians. And there were many other indigenous peoples that occupied this area that is now known as Texas. And I'd like to first just take a minute and invite them and those ancestors to be here with us today. I'm going to start us off on a little serious note, if I had my glasses. Thanks. I'm still in denial that I need glasses, and so I always forget them. This is a poem by Suzanne Schoen Harjo, who's Muskogee Creek. She won an honorable gold medal from Barack Obama. She's an activist. She's a poet. And this poem's called A Child of Time. A child of time, naked and weeping, walked one night in my dreamless sleep. She came to claim my word of honor, the promise she heard me make to keep. Her voice when she spoke was the sound of the wind first howling, then moaning and sighing, the sound of a storm without end. She knew of my early morning visit to the Museum of Indian Dead, where I had stared at her small, torn gown of leather and beads, all stained with red blood, should mean something more than this. Blood flows and lives and gives again, but here, only dead rust patterns surrounding a bullet hole where her belly had been. To most, it was merely a dress on display, placed next to the ancient Navajo loom, lighted and indexed for all the curious patrons of this bone-chilling public tomb. This dress of dried blood does not belong here. It should be saged and secretly burned. And now, with the dawn, her voice on the wind, I'll walk this way till my spirit's returned. No dramatic pause. A little too long dramatic pause there. Help? There we go. So when the Americas was colonized, there were a lot of things brought to this place besides religion, besides disease, besides metal and weapons and horses. What was brought was a perception and a way of thinking that was different than what was here before that event took place. And there's something that kind of encapsulates what that was. It's called the doctrine of discovery. Has anyone here heard of the doctrine of discovery before? The audience shows 3 hands. The doctrine of discovery came from civilized nations who claimed that where they entered land that was occupied by non-Christian peoples or heathens, that the land was free and clear for them to take. And so that was what came here and displaced the peoples that were originally here, who had vibrant cultures, families, lives, and ways of thinking and being. The peoples that came here respected their own dead, but not those of the indigenous people. And that foundation principle of the doctrine of discovery also helped to institute how the U.S. government would treat indigenous peoples as those first couple of hundred years passed. I'm going to go quickly through some of these things, but I think it's important that we remember the context of history and how indigenous peoples' belongings became part of kind of Western culture in museums and other institutions and in private hands. So U.S. federal Indian policy is a very unique animal. It is, and I got into it as a lawyer, as a law student, as a student of my own history and indigenous peoples' history, because it was the weirdest thing I've ever read, where you would normally have an interesting property issue that normal common sense would give you a certain outcome. When Indians were plopped into the mix, it was completely nonsensical. And what I found after reading court case after court case after court case is there was this deep racism based in that doctrine of discovery that kept playing out in these legal cases, creating this policy of this other peoples that separated them, that assimilated them, took away their children for in order to assimilate them, and stole their belongings and robbed their graves. And this history, though, it's past. It's our past history. We don't do this today. Still affects Native American communities in a deep and profound and tragic way quite often. And so let me just give you a little blips, a couple of samples here. I want to tell you that there was a man named Samuel George Morton who was into phrenology. Are you all aware of a study of phrenology? That's when you study the size of the brain and make assumptions on someone's intelligence based on the size of their brain. So he often used indigenous people's skulls to do this, and of course come to find that indigenous people, based on this now outmoded science, were less than. And that was a strong foundation for the early United States to continue to push for assimilation, continue to push for Indians to be removed from their original homelands. In 1867, the Surgeon General actually had an order, a policy for people to collect Native American human remains for study. And there was a great science, a great interest in studying Native American human remains. And with that came also, because graves were being looted, these what some would call wonderful and amazing types of items that became part of trade throughout the United States and all over the world. And those items have become parts of our institutions all over the United States. And I gave you a little quote there by Thomas Jefferson as I move on here. It was just an accepted practice. It was part of that understanding, this heathen culture, non-Christian, unlike us, in our way of progress, in the way of manifest destiny, that it was okay to violate those basic human rights that I would imagine we wouldn't consider something we'd want to practice today. Again. All right. So as I talked about, this was really the creation of the tribal art market. So museums clamored for this. Museums competed with each other to get the most stuff and to get the best stuff. And there was a gentleman by the name of George Gustav High. If you know who that is, then you understand who the National Museum of the American Indian is today. George Gustav High in the 1800s and 1900s for about 45 years would go into indigenous communities throughout the United States and take railroad cars full of indigenous, cultural, sacred items. And this was seen as an okay thing to do because at the time it was understood that Indians were the vanishing race, They were the disappearing peoples, and museums and anthropologists and archaeologists were clamoring to take in that information and protect it for the good of mankind forever. And often indigenous peoples were put under duress to release those types of sacred religious items. And by the early 1900s, tribes were in such a place in the United States that they didn't have the capacity to stop the kind of the non-Indians from overrunning lands and properties and sacred places. So George Gustav High just had this enormous collection that was not well taken care of, and for the next 70 years, that became the place where museums and dealers and traders would go to pass items and pass objects. Today, sometimes you'll still see things auctioned off at Sotheby's or another auction house with those High Museum, the American Indian Museum tags on it. So it continues to be this legacy of this trade in what is known as tribal art. But in reality, these items are human remains. They are funerary burial items. They are cultural patrimony. Those are objects that belong to the culture, to the nation, to the tribe, and religious items for ceremonial purposes. All right, and I wanted to let you know that boy, this is kind of depressing. I need to uplift this somehow. Going back, I wanted to show you these items. They're not the most dramatic items that are in museums today, but these I have permission to show. I wouldn't show those kind of sacred items in this kind of, or without permission. And just like in a museum, these items are completely taken out of their context, out of their story, away from their people. So all you see here is a pipe, a headdress, and a wampum belt. And I would encourage you, when you go to museums and see these types of things hanging on the wall behind glass, whether you learn much more about them than that. So there's not much story there to tell. All right, I better speed this up, huh, guys? Got another lawyer following me. So let's talk a little bit about the changes. So federal policy was really horrible in Indian affairs. There was assimilation. There was allotment. There was attempts to terminate and assimilate and kidnap kids and send them to boarding school, outlaw languages, outlaw cultures for most of the 20th century. And then in the 1970s and thereafter, there was a movement towards tribal self-determination that federal U.S. Policy supported after Nixon. And in 1990, there had been some legislation before the Native American Graves Protection and Repatriation Act called the American Indian Religious Freedom Act that was passed to help support tribes in their practice of religions, the use of sacred sites, and their return of items. But it was rendered by a case as unenforceable, no teeth, and didn't do anyone any good. So in 1990, actually before that, in 88 and 89, there was a Repatriation Act called the NMAI Act, which applied to the Smithsonian Institution and provided a process by which the Smithsonian Institution, including Gustav High's National Museum of the American Indian, which is now known as the National Museum of the American Indian, a process by which those Smithsonian institutions would repatriate through consultation with tribes and further research. This was really the first piece of human rights legislation that applied to Indian people in the United States. It applies to federal agencies and museums. And museums under the Act are defined as any institution, historical society, state division, that has received federal funds. So if you've received any federal funds from 1990 on, NAGPRA applies to you. And what you have to do is first determine if you have cultural items under NAGPRA. And the federal law has acknowledged that there are certain types of items that are extremely sensitive and must be repatriated to indigenous peoples here in the U.S. And those include, like I said before, ancestral remains, their burial belongings, cultural patrimony, and sacred objects or religious items. And what a museum or federal agency has to do is inventory and provide summaries for those types of items. And the Act gives a legal process for following the Act. It also requires, it forced institutions to talk with the indigenous peoples whom objects they had. Incredible. Guess what came out of those consultations? Amazing relationships and information that was never before known by those institutions, because oftentimes they found that they had wrong, incorrect information, because part of that art market, that grab of objects and ancestors from the ground, came with fabricated stories of what the provenance of those items actually were, in order to separate them from their original peoples, and also to create a more romantic or different story that had a very more Western perspective of and interpretation than what the object truly was. And truly, those items are not objects of art, nor were they created by artists, but they are living, breathing, and still objects still being used today for tribes. So consultation, and then there's process of repatriation. And one thing that always museums have trouble with is this process of repatriation, because it's a legal process and it's not a scientific process. It's not about whether an item has some kind of scientific certainty to have originated with this particular group or tribe. It's dependent on a whole body of evidence that can include oral tradition and elder and traditional knowledge, as well as other experts and internal native experts to add to the story that the museum has possessed. And since its implementation in 1990, just to give you some numbers, 57,000 ancestors have been repatriated. 1.7 million burial items have been repatriated, and 15,000 sacred objects and objects of cultural patrimony. So truly a human rights law. I put a little bit in here about Texas because I'm always interested in what states are doing. Some states have their own NAGPRA. Texas does not, surprisingly. I don't say that with any sarcasm whatsoever. They do have a cemetery protection, and so unmarked cemeteries are somewhat protected on state lands. But if something is on private lands, you can do just about whatever you want with it. So just to give you a quick limitations of the law, one is that NAGPRA only applies to items that are in museums or federal agencies. So they don't apply to private parties, even though the same items that are in museums are also being held by private collectors and still have the same sacredness, the same a meaning to indigenous peoples today. And if we can compare it real quickly to other laws in the United States, like the Gold and Bald Eagle Protection Act. For example, if a bald eagle dies in my yard at home, which is not within a reservation, I have no ownership of that. Fish and Wildlife come, they take it, and I can't, if I sell it, if I have it, I can be charged criminally for it. But if the same place where the eagle fell, if I move him over and start digging in the ground and I find burials or other items, they're mine. So, and it's that fact that has ruined much of the real scientific work that could have been done if there was a different perspective on these issues. So, and then quickly, and I'm going to move here quickly, I keep saying that. One of the things that's missing in here is that many of the private collectors and auction houses and dealers that deal in Native American art is that they don't understand there's other laws that are applicable besides NAGPRA. There are other criminal laws. There are even tribal laws that could be applicable to these items. And so part of what my organization has been doing is trying to make sure people understand that just because the item doesn't fall under NAGPRA, that doesn't mean they're free and clear and have the right to possess any particular item. All right. Well, now here's the good stuff. Just this year, what are we in, the 4th month now? Just this year, there has been some amazing movement and changing perceptions all over the world regarding indigenous peoples' cultural property. In November 2018, the French Republic released a report about African cultural heritage and about returning those colonial-era items. In December, there was huge protests erupted in the British Museum about decolonizing that institution and calling for the return of colonial-era items. In March, just around the corner here, the Netherlands National Museum of World Cultures announced their intent to begin returning cultural items taken during colonial times and even have a process by which those items can be returned. And I put the 3 points that they look to work with indigenous peoples and others for the return of items in their collections. Germany, 16 states in Germany joined a joint resolution to set guidelines to repatriate items from its former colonies. And I like this quote: all people should have the opportunity to meet their rich material cultural heritage in their countries and communities of origin, to interact with it and pass it on to future generations. And there have been some other countries that have followed suit. Scotland has been repatriating to a Canadian First Nation just this year. The England National History Museum just repatriated quite a few ancestors to Aboriginal and Torres Strait Islanders. So there are exciting changes in perceptions that nothing like this has ever happened before. And with that, the U.S., believe it or not, is actually changing some of its perceptions about how it looks at these issues. Just in 2016, there was a concurrent resolution by the House and the Senate supporting efforts to stop theft, illegal possession and sale, transport and export of tribal cultural items. And currently today there's legislation called the STOP Act, the Safeguarding Tribal Objects of Patrimony Act, that is setting forth import restrictions and other types of protections to enhance and protect cultural heritage that seems to be trafficked to other market countries, art market countries. GAO released a report last year as well about the theft of Native American cultural property. By the way, that looting still happens and is still prosecuted today. And as I said, AAIA, the association, has been involved in trying to provide notice to people who are interested in collecting Native American cultural heritage and warning them that laws and perceptions are changing and that the investment in those types of items that are sensitive is not worth it. And instead, we should be focusing on contemporary Native artists to tell the story of culture and Native American heritage. So, to conclude, if I'm looking at the right thing here. I just want to provide a little bit of a summary of some ethical considerations, considering the colonial history of theft and looting and the federal policy against Native American cultures, and considering that U.S. law has defined what those sensitive items are that should be protective, and also considering what's happening internationally and in international human rights law, including the UN Declaration on Indigenous Peoples' Rights, that protect Native American cultural heritage. That first and foremost, Indigenous peoples are the experts of their items. Too often, myself and my colleagues and tribes who work in this area to try to get items back are met with holier-than-thou attitudes from museums and institutions. Does that surprise you? That wasn't a good joke? Okay. So instead of listening and being open to the knowledge, the thousands of years of knowledge and understanding that Indigenous peoples in this country have about their items, I think that's one of the number one difficulties that we have in this work, is trying to get past that wall of I know what's best for our collection. Indigenous peoples are the experts. There are so many opportunities to work in collaboration with tribes and tribal nations that protects and sustains cultural heritage and helps build and replace that historic trauma that we have felt for the last 500 years with free, prior, and informed consent, with dialogue, with discussion. And we urge institutions and private collectors and museums to create a higher level of due diligence when they're working with Native American cultural items, and include potentially affiliated tribes in those discussions. It's the only way that we can truly make right that which has been so desperately taken away from those items that have been so terribly taken away from the heart of their people. And what I think is even more promising is this opportunity to work with contemporary Native artists to tell a story that connects Indigenous people with the public in a much deeper way than what those bare items on the wall can give. I want to invite everyone in November to our Repatriation Conference. This is an annual event that we have. It's going to be in Arizona this year. And this year we're focusing on bringing institutions and private collectors and auction houses and others to the table with us, so that we can work together and find some healing. And so if you're interested in it, please let me know. And that's all I have. I really appreciate your time, and I hope I helped kind of stretch it out a little bit. Okay. Thanks, everyone.
Thanks a lot, Shannon. I'm going to introduce now Stephen K. Urice. He's a professor of law at the University of Miami School of Law, a former archaeologist and attorney. Stephen practiced law in New York and California. He served as a museum director and foundation executive, and in 2006 joined the University of Miami Law Faculty. He co-authored Wills, Trusts, and Estates, 3 Essentials, and is now working on the 6th edition of Law, Ethics, and the Visual Arts. He serves on the faculty of the American Law Institute's annual course, Legal Issues in Museum Administration, and was academic advisor to the Aspen Institute's Artist Endowed Foundations Initiative. With you, Stephen.
I assume this is the mic? Or is that the mic? No, this is not. That's my light. Okay. It's going to be a good afternoon. Okay. Well, good afternoon. And I would like to add my thanks to Steve and to Danielle and to the staff of the Harry Ransom, the HRC. That's easier that way. I did spend 5 years of my life as the director of a rare book institution, rare book manuscript collection, the Rosenbach in Philadelphia, and it feels really good to be back in this environment again, especially after having spent now so many years in a law school. So I feel quite comfortable. But this morning has set a very high standard for us. We'll see if we can meet it. Ethical Challenges in Cultural Stewardship. That's our symposium. And I've been asked to talk about the back end. How do you get rid of this stuff? Not how do you acquire it ethically, how do you steward it while it's in your possession, but what do you do when you decide we can't keep it or we don't want to keep it? So I want to start with, and the title of this presentation is Ethical Deaccessioning. Deaccessioning came into the public eye quite suddenly with an article in 1972 by the chief art critic of the New York Times, John Cannaday. And the circumstances under which he was writing the article has permanently smeared the term deaccessioning. His editor entitled the article Very Quiet and Very Dangerous. And he reported that the Metropolitan Museum of Art had deaccessioned and then disposed by sale, very quietly, of a group of paintings that had been bequeathed to the Met by a longtime supporter by the name of de Groot, hence the de Groot affair. They had the legal authority to do so. Under her will, title passed from her to her estate to the Metropolitan Museum. There was a precatory instruction, not a legally binding instruction. It was a request that if the Met ever chose not to keep any of the works, that they transfer it to another museum. Instead, they sold the works. And so with Cannaday's article, the term deaccessioning in 1972 came into prominence. Now, in that article, and this is why I really want to start with terminology, Cannaday confused things. That confusion, particularly among journalists, continues, again in Robin Pogrebin's front page article in the New York Times a few weeks ago on deaccessioning. So let's get our terms straight first. Deaccessioning refers to the removal, the permanent removal of a work that has previously been accessioned into the collections of a museum pursuant to action of its governing board. All right? Deaccessioning is merely the decision to remove the item from the collections. Disposal Disposal is a different term, and disposal refers to the means by which the museum's title in the work is transferred to the successor in interest. I'll try to keep legal jargon down to a minimum. Canaday defined deaccessioning as sold, and so did Pogrebin in her recent piece. And it's really important to distinguish deaccessioning from disposal. Why is that? Because sale is not the only method of disposal. Following deaccessioning, works from collections could be and are disposed of by exchange with other institutions. They are often transferred by gratuitous transfers. Let me give you some examples. If there's a change in museum mission, then it's inappropriate for the museum to continue to expend funds stewarding works that do not support the mission. In that case, some museums may deaccession, some may dispose by sale, others may dispose by transfer to other institutions, collecting institutions. A gratuitous transfer occurs when works are restituted to previous owners, and the example there I would provide are the many instances in which U.S. museums have restituted works to Holocaust victims or their descendants that were originally looted from those individuals' families. And gratuitous transfers also occur in situations of repatriation, when a museum determines that a work that has been accessioned to its collection needs to be returned to its either country of origin or country of modern discovery. Disposal can also occur by destruction. The Code of Ethics of the Association of Art Museum Directors explicitly addresses that possibility. And they point out, quote, as in the case, destruction is appropriate in the case of false or fraudulent works or works that have been irreparably damaged or cannot practically be restored. So, it's disposal by sale, however, that has created the greatest attention in the public's eye and among journalists. The issue with sale as a means of disposal is not so much whether you sell with in public auction or through a dealer. That was for many years argued on both sides. The real issue is what do you do with the proceeds of sale? Do you use it, does the institution use it to acquire new works? Does it use the proceeds of sale to care for works in its collection? Does the institution use the proceeds of sale to cover operating deficits or to retire debt from capital expenditures? I'll come back to those possibilities later. Now, as a matter of law, all right, and as José pointed out, I'm working on the 6th edition of what had been what is the very first text for law students in the field of art law, which was originally published in 1979 by John Henry Merriman and Albert Elson. And John and Al very purposely titled that text Law, Ethics, and the Visual Arts. I came on the 5th edition and continuing now with the 6th. So I think it will be clear to you that law has very little to do in this area of ethical stewardship of collections. The basic rule, the general rule, is that in the absence of a legally enforceable donor-imposed restriction on the object being deaccessioned, or absent legally enforceable limitations in the collecting institution's governing instruments, for example, the will of Isabella Stewart Gardner, which created a testamentary trust, which created the Isabella Stewart Gardner Museum. The restriction is very clear that no work may be sold unless it deteriorates to the point that it can't be exhibited, or hung in a different location, and nothing else can be added to the collection. Those are very clear terms. So, in the absence of a legally enforceable donor-imposed restriction on the gift of the object or in the collecting institution's organizing documents. A non-governmental museum its governing board may generally deaccession and dispose of works as it determines. The common law always disfavored limitations on alienability. And so the common law approached these issues with a fundamental bias in favor of the transfer of property. And that remains the rule. But it is no answer to the question about deaccessioning. As I think all of you that manage museum collections, I hope all of you are aware of Marie Millaro's great book, Legal Primer on Managing Museum Collections. Came out first in 1985, a second edition in 98, and then a third edition co-authored with Ildiko De Angelis in 2012. And in a memorable talk, Marie at one point said, the law merely makes us bearable. It doesn't make us honorable. So let's shift from that quick legal summary to the real issue, which is what is ethical deaccessioning? All right. Now, upfront admission, my approach to ethics is deontological. I see ethics arising out of duties, and I think that comes out of a legal training as well as out of my art historical training, rather than its consequences. So that's my bias, and you'll hear it reflected in what I have to say. Ethics arise, in my point of view, from duties. Hence, actions that fulfill duties that are imposed are ethical actions. Now, that takes care of a couple of millennia of debate on ethics. And I emphasize duty because collecting institutions are subject to at least three bodies of law that impose duties on the museums or the other form, on collecting institutions, on their governing boards, and even on their staff members. And it's out of these legally imposed duties that ethical obligations arise. Quick comment. The U.S. museum system is unique in the world. Our museum system is primarily privatized. By that I mean it's non-governmental. Collecting institutions in this country occur in the first sector of our economy, the governmental sector, the second sector, the private for-profit sector, and in the third sector, the private nonprofit sector, which is where most of them reside. So as private, not governmental, so non-governmental, I'll use that term instead because journalists have really screwed up the use of the term private museum. There is no such thing as a private museum if it's tax exempt, but we can talk about that another day. But there are on these institutions that have gained recognition as tax exempt under 501c3 of the Internal Revenue Code, a whole group of legal obligations. I'm not going to go into any of them in any detail, but the institution must follow the imposed obligations in exchange for the perquisites of being tax exempt. Collecting institutions have governing boards, and those governing boards have imposed on them, typically by statute, if not by common law, in all jurisdictions, very basic fiduciary duties. A fiduciary is somebody who occupies a position of trust. And those duties are often summarized as a duty of care, to act as a reasonably prudent person would, a duty of loyalty, that is to make all decisions as a member of the governing board from the light of what is best for the institution and not the self, to avoid conflicts of interest. And many assert that there is also a duty of obedience to mission. The third way that the law imposes on collecting institutions is on the collections themselves. Although we tend to think of collections in a different way, the law looks at them pretty simply. From a legal perspective, most objects in a collection are tangible personal property. The law treats our collections typically no differently than it would treat a hammer or a pencil. And that's particularly true of the buying and selling of collections items. The Uniform Commercial Code governs the sale of collections items just as it covers the sale of a ton of bricks. Now, rarely, collections items may take other forms. I'm thinking of something like Robert Smithson's Spiral Jetty, which is owned by the Dia Foundation. That is real property, actually. It's real estate. And with conceptual art, we've entered a very interesting area where where the collection item is an intangible form of personal property, because with conceptual art, what one buys is a license to reproduce the work. Okay, but in general, we're talking about objects, tangible personal property. And as Shannon has just pointed out, portions of these collections are going to be are subject to various legal obligations, NAGPRA being one of them, Native American Grave Protection and Repatriation Act of 1990. Shannon is such a diligent director of her organization that within 20 minutes of our first conference call together, I received an email from her informing me that a museum on whose advisory board I sit was not in compliance with NAGPRA. And I really have to thank Shannon for it. So vigilance is everything. Our collections are subject to, for example, federal law known as the HERE Act, the Holocaust Expropriated Art Recovery Act of 2016, which establishes a federal statute of limitations for the recovery of Holocaust art. So in terms of our institutions, in terms of their governing boards, and in terms of the collections themselves, the law has a great deal to say. Now, again, the legal parameters are very simple with deaccessioning. I've already gone through those. It may be helpful to think about why do our collecting institutions deaccession objects. And typically there are 5 reasons. I'm sorry, let me rephrase that. Typically there are 5 separate concerns in a decision to deaccession. Let me run through them. The first is, why is the institution deaccessioning? The second is the legality, meaning, is there a legally enforceable restriction on the decision to deaccession and dispose? The third is, what is the institution's policy on how the institution determines whether a deaccession will occur? Does that decision arise, as all of our codes of ethics applicable to collecting institutions require, does that arise from the curatorial staff, meaning the decision is fundamentally predicated on a curatorial determination, or is it imposed by a board, a governing board, which may suggest that other considerations, particularly financial, are at work? The manner in which the deaccession work is disposed of, and again, the use of sale proceeds. Now, reasons for deaccessioning. New York comes in very helpfully here. The Board of Regents of the state of New York, which is responsible for chartering all museums in the state of New York, has regulations. And in the regulations, they mandate that every museum, every collecting institution in New York adopt a collections management policy. I know of no other jurisdiction that does that. And a necessary component of an acceptable collections management policy for the Board of Regents in New York is an explicit policy on deaccessioning. And the reasons acceptable to the Board of Regents are as follows. Reasons for deaccessioning: the item is inconsistent with the mission. The item has failed to retain its identity. The item is redundant. The item's preservation and conservation needs are beyond the capacity of the institution. The item is deaccessioned to accomplish refinement of the collections. I think I'm missing a page. Did I miss a page? Well, no, I'm not. Sorry. There has been a determination that the work is inauthentic. the institution is repatriating the item or returning the item to its rightful owner. Repatriation on the one hand, restitution on the other. The item the item is being returned to the donor or the donor's heirs because the institution feels it can no longer meet the donor-imposed obligations, the restrictions on it. The item presents a hazard to people or other collections items, or the item has been lost or stolen and has not been recovered. There's a very important case in New York called Guggenheim v. Lubell, Guggenheim Museum, and that's exactly what the Guggenheim did. The Guggenheim lost a Chagall, and so they deaccessioned it. 3 years later, it was found. But what do you do? What legal rights do they have then to a deaccessioned work? We won't go into that now. Okay, we've already talked about who decides and the means of disposal. The real question is, what does a museum do with sale proceeds when disposal is by sale? All of our museum service organizations limit the application, the ethical application of sales from proceeds from the sale of deaccessioned works to one of two purposes only: either the acquisition of new works or what is referred to as direct collections care. Now, direct collections care is very interesting. I think many of you are probably familiar with it. The AEM's first Code of Ethics came out in 1925 or 1928. I think it was 25. They did not revise their Code of Ethics again until 1978, and then in 1991 they promulgated a new Code of Ethics. And the new Code of Ethics kept the standard that the only acceptable application of sales proceeds was to acquire new collections items. Now, remember, AEM is an umbrella organization. Art museums are only one component of that. And AEM got tremendous pushback, particularly from natural history museums, collecting institutions with living collections, botanical gardens, and aquaria and zoos. And so 2 years later, AEM expanded acceptable use of proceeds of sale from deaccessioned works. And the 1993 restatement in the Code of Ethics of AEM states as follows: disposal of collections through sale, trade, or research activities solely for the advancement of the museum's mission. Proceeds from the sale of non-living collections are to be used consistent with the established standards of the museum's discipline, but in no event shall they be used for anything other than acquisition or direct care of collections. Well, that satisfied everybody until we all realized we had no idea what direct collections care meant, right? So it took a number of years until AEM convened a task force to define the term in 2014, and that report came out in 2016. So we now have a better sense. Direct collections care does not mean putting on a new roof. It does mean conservation efforts on this piece. Now, the art museum community, to the extent of the members in the Association of Art Museum Directors. And note again, AMD is an association of directors, not an association of museums. But AMD restricts funds from deaccession works solely to acquisition of new collections items. It states so both in its Code of Ethics and in an appendix to that code. Let me just quickly read it. Funds received from the disposal of a deaccessioned work shall not be used for operations, or capital expenses. Such funds, including any earnings and appreciation thereon, may be used only, and that's important. In other words, you sell a work for $30 million, it will generate investment income. And AMD very specifically addresses what you do with that income, all right? So, such funds, including any earnings and appreciation thereon, may be used only for the acquisition of works of art in a manner consistent with the museum's policy on the use of restricted acquisition funds. In order to account properly for their use, the AMD recommends that such funds, including any earnings and appreciation, be tracked separately from other acquisition funds. So where do we stand with deaccessioning and ethics? We could go on all afternoon. I could very easily go on all afternoon with examples of what I would call good ethical deaccessionings and those that I think, and all of us, I think, would probably agree, fail to meet existing professional ethical standards. Let me close these comments so we can get into our discussion and questions from the floor by returning again to the late Marie Malaro, whom I first met Marie in 1987, which was when I first attended the American Law Institute's annual course of study, Legal Issues in Museum Administration. I gave a memorial minute for Marie last week at this year's annual course of study, and in the middle of delivering that, I stated, and it was true, that the deepest impression I have of Marie was from her keynote address at the 1992 meeting of that course of study. And as I said the words, I realized half of the people in this room weren't born in 1992 or were in infancy. But nevertheless, it stayed with me ever since then. And that was always to remember that our collecting institutions reside in the third sector, in the private nonprofit sector. And therefore, their behavior, the perquisites we enjoy in the third sector, tax exemption primarily, require us to behave in a very different way than for-profit institutions or governmental institutions behave. More succinctly, as Marie put it, the best deaccessioning policy is a smart accessioning policy. And let's end with that and get into our conversation.
Thank you, Stephen. Before opening the floor for questions, let me ask this to Shannon. Let's say, Shannon, that a native group has a legitimate claim over an object or a document held at a museum or at a library, but the group is unable to preserve the object or provide access as effectively as the institution. How should concerns over preservation and access, two words that we use a lot in this kind of institutions, how should those concerns be part of the discussion about repatriation or deaccessioning of collections? Upon hearing your talk, I added this part of the question. Are those concepts even relevant when we talk about repatriation?
Right, and I don't have a very good answer that anyone's going to like in this room. It's none of your business, quite frankly. Items that have been taken and misappropriated from indigenous peoples are not the institution's items from an indigenous perspective. And so when we bring those back home, what we do with them is our business. And there are different things that we do depending on the item. Often items in institutions have been treated with poisons. And so sometimes they need to be buried and put to rest. There are other items that can be cleaned and supported and put back into cultural practice. I neglected to mention that the items that tribes wish to be repatriated don't always fall under those NAGPRA cultural items definition. And there are many other types of items that tribes often work and collaborate with institutions to try to get returned. Some of those are documents, photographs, and other materials that may not fit the sensitive items type of definition, but that are important to rejuvenating certain cultural practices. And so I guess the short answer to your question is it's not your business.
Thank you.
Can I just add one,
Yes.
just something to that,
Yes.
which is it's been a canard for more than a century as to why Western encyclopedic museums resist repatriating antiquities in particular. Well, the reason for it is we can take care of these items, those countries can't. When it was discovered about 20 years ago that, in fact, in the 30s, the British Museum had steel-wooled and scrubbed the Elgin marbles to bring back their pristine whiteness, which they never had originally, it really kicked that argument out the door. And in fact, it's just simply not an argument that holds water. It may be true that some countries of origin don't have funds to care for some pieces, but it's not necessarily a reason not to do it.
Correct.
Thank you. Very, very, stimulating. Simply, it's not what it's not what I expected. It's not what I had considered before. Not before hearing your talk. Stephen, may I ask you to give us a quick example of deaccessioning of an object in which that you think doesn't meet the ethical standards, that you think was done poorly, that failed in some way to meet those standards?
Mm-hmm. Unfortunately, there are too many of them. So let me take two quickly. The Delaware Art Museum, typically the situations in which museums, at least, deaccession and dispose by sale is to generate funds to cover chronic operating deficits or to retire debt. Delaware Art Museum in the early 2000s expanded into new buildings. It floated a $20 million bond to do so. It was coming up for renewal, couldn't afford to do it, and it announced the board, if the decision came from the board, not from the director or the curatorial staff, to sell certain of their works, which they did, and they were sanctioned by AMD. They were an AMD, the director was an AMD member, although she had resigned when this issue came up. And so they did not realize at public sale what they thought they would get for a major Pre-Raphaelite piece, which was one of their great strengths, was a great Pre-Raphaelite collection. And 2 years later, they then very quietly sold two other pieces privately. So the reasons for the deaccession, the application of the sale proceeds, the lack of transparency and accountability, all put that at a really high level of unethical practice. The other one I would give you is the National Academy Museum in New York. I'm trying to remember when this was. I think it was around 2005 or so. 2006, quietly sold two of its major pieces in order to generate funds for to meet operating expenses. When it was discovered, the museum's position was, this is what's going to save us, we'll be fine. In 2016, it announced a sale of its buildings. So in both of those cases, I will tell you, I do not know of a single example, and I'd be delighted to learn of one, where a collecting institution has deaccessioned and disposed by sale of works either to cover operating deficits or to retire debt that has subsequently gone on to financial security. So when you see a collecting institution at that point, what you are seeing is a collecting institution that has been poorly governed, not necessarily poorly run by its staff, but it's a symptom of failed governance. And it's, from my perspective, because I don't know of any examples, almost impossible then to pull itself up and out by selling parts of its collection.
Thank you. Thank you, Stephen. I want to open the floor for questions. Anything, comment, or question? Yes. If you would wait for it.
Testing this one. IV equipment always fails.
Yes. Batteries die.
My name is Jim McNutt. My question is, can you explain the standing of the position of the museum associations, AAMD and AAM, with respect to ethics on deaccessioning in a courtroom? That is, what's the legal standing if the board of trustees of a museum undertakes to sell, to deaccession and dispose of something by sale to put a roof on the place? How does that work?
All right. The way that works is very simple. The service organizations do not have standing. However, they may be permitted to file an amicus brief with the court stating what their position is. Also, the Code of Ethics of AMD provides a penalty for violating their Code of Ethics as it applies to deaccessioning. The sanctions essentially isolate the institution from loans and other relationships with AMD members. They've imposed those sanctions. They've also withdrawn them after a period of time. But I know AM's deaccessioning standards do not have an enforcement provision, and it's been a few years since I've looked at some of the others, but I believe AMD is the only one with a sanction. And again, they would have no standing. The only people with standing are the governing board of the institution and potentially certainly the Attorney General of the state, and potentially, if we're dealing with the work that a donor-imposed restriction, in a few jurisdictions, the donor might have standing.
Other questions? Yes.
Thank you. That was very interesting. I think this is a question for Shannon about how you experience the overlap and or tension between indigenous frames and legal frames, since you're someone who inhabits both worlds and identities. And I'm interested in kind of indigenous perspectives on the way in which conventional law is organized around property and notions of private property. And so what happens if objects, artifacts, although I'm interested in perhaps the way that indigenous frames push what we think of even as an object, because also people have been objects of property. Objects can be alive. What would it mean for all of us to sort of think outside certain conventional frames? And I was interested in one of your slides, kind of thinking about other terminologies. There was the phrase tangible cultural heritage, and I would be interested in kind of the force of something like that, where tangibility brings us to something material, but it also speaks to something that is cultural, or that is beyond, not just a bounded object. It's already like embedded in cultural processes, traditions, and so on. So you can't just like take it away or decontextualize it.
That's a really complicated question, but a good one. Kind of how do you communicate, right? How do you communicate from an indigenous perspective to and a Western perspective in order to work together on these issues? And it's not always easy. And I'm not even quite sure how to answer the question, because it really is a conversation about being open and listening. So let me tell you a little story. So that wampum belt that you saw up there, that was one of those items that had been traded in the 70s when the Museum of the American Indian was actually being investigated by New York Attorney General for illicit trading between museums and dealers for money, which was contrary to the museum's purpose as a charitable organization. And that wampum belt was one of those items that was traded during the 70s and wound up at Sotheby's in 2008 for sale with that little Museum of the American Indian tag on it. And that belt is a Haudenosaunee, an Iroquois nation belt. And there were a few of those belts made, and they were belts to communicate ties between the different nations within the Confederacy. And that one belonged to a community just this side of Canada, a Mohawk community. And those belts often were messages. They may have red put on them if it was time for war or for other purposes. So that's just some and there's a lot of people who have expertise in what wampum is and that they were treaties. They really are considered cultural patrimony belonging to a nation, like a flag or the Declaration of Independence. But when we brought the delegation of Mohawk elders to Sotheby's to see this item and to look at it and to communicate with it, something profound happened to everyone in that room, including Sotheby's attorney. At least I hope so. And he cradled that belt, and he spoke with it, and he cried. And he said, "How can you put this child in a drawer and leave it there?" The belts have a more spiritual, and there are spiritual people in certain nations that can speak to the beads and the intent that was woven into that belt. And it has more meaning than anyone in that room, except for that Mohawk delegation, realized. And so the only way you can communicate that to Western thinking or Western thought is, I think, with that type of openness and dialogue. I don't think it can happen in a vacuum, but it has to be done together and in collaboration and with patience and proper attention. Did that answer your question?
Can I ask something?
Yeah.
It's very interesting you mentioned that case. Lefkowitz v. Museum of the American Indian, a complaint was filed in 1975, and it's the first instance I know of a state attorney general suing a governing board of an institution for failure to meet their duty of care. And it was a settlement in that case that led to, for the first time ever, an inventory of George Gustav High's collection, which is interesting because it's a huge collection of what it is, but compared to other museums, it's not overwhelming. It really started the ball rolling, which eventually led. What was interesting is the indenture from High in creating the museum repeatedly states in the city of New York, for the citizens of New York, on and on. And so there had to be a legal proceeding, what we call a cypre proceeding, to get permission to remove that collection to Washington. But the court would agree to that only by retaining a small portion of the collection in New York to satisfy High's restriction. But it really was Attorney General Lefkowitz that for the first time, and it really had an enormous impact. board members for the first time realized they could be civilly liable and potentially criminally liable for failing to live up to their duty of care as board members.
Thank you, Stephen. I think we have time for one more question. Somebody had raised their hands.
Hi, my name is Christina Favretto. I'm at University of Miami Library, Special Collections. And Stephen, we've never met, but boy, do I have to talk to you at some point. My question is harking back to comments that were made about a code of ethics and also curatorial decision-making. So libraries are ethical places generally, but that I know of, we don't really have a code of ethics like museums might. That said, we do accept collections, and sometimes these decisions are made for us. There'll be a trustee, a friend, a potential donor who might donate for a building, but we should also take their collection of blank. And sometimes within these collections are questionable items. However, if questions are raised, it could be a career-ending move at that institution. It's a very sticky problem, and I guess my question is, how can we start a conversation about creating codes of ethics for libraries that particularly will address issues faced in special collections and archives?
My understanding is that the ALA does have a code of ethics, and that the RBMS, the Rare Book Manuscript section, also. Is it a separate code? Or is it part of it? Right, separate. That's right. Okay. So there are promulgated codes of ethics, but in a way, your question is fascinating because part of that problem is the problem of embedded institutions. In other words, a special collections entity at a university is within and under the control of the university's governing board. The same problem with college and university museums. And embedded institutions have a whole group of challenges that independent entities don't, such as the one you just mentioned. And in fact, AMD created a number of years ago a section specifically for directors of university and college art directors, and a great deal of their work addresses those particular problems. But I'm happy to talk with you anytime. But you know what they say, free legal advice is worth what you pay for it. And so,
I saw that Astrid had raised her hand, and we have 5 minutes, and I think we can quickly.
Thank you, and thank you to both of you for your presentations. I wonder if you would maybe consider stretching some of the definitions of the kinds of things you talked about, because both of you presented on items or objects that we can easily envision as things, whether they're cultural things or artworks. But I wonder how some of what you presented might apply to documents. So collections that are also objects. But for example, I'm thinking, how would deaccessioning work if, say, a museum that owns an artwork, like a painting, also has a number of records from the correspondence with the collector that donated those items, or sometimes maybe the painter himself or herself, and they might decide that they're going to sell some of those letters, for example, and deaccession those to an archive on the life of that artist or collector. And likewise, in the case of NAGPRA, for example, I'm thinking, where are the limits of the idea of a cultural object? For example, if we think about photographs in an archive, photographs of the likeness of indigenous people that might have been taken without permission or under duress, where there might not be records of that agreement to even take those photographs, whether staged or candid or however. Like, how do we deal with the difference between what you've talked about and what, say, libraries or archives might be dealing with?
You want to go first?
Okay. My very first public paper after getting my law degree was on every will I'd ever seen that made a gift of a work of art simply gave the work of art, and this paper said it really should state work of art and all files, records, documents, etc. pertaining to that work. Nobody does that, but that's the way you should transfer works. In other words, to the extent there's documentation, it should follow the work. I think your question is fascinating, which is, what if an institution decided to sell some of that documentation related to the work, but kept possession of the work because, let's say, it had been donated by a famous author and the letters might be more valuable than the object. And it's a very interesting question. I haven't thought of it. Manuscripts always have a slightly more complex set of questions with them, but ultimately they too are treated as tangible personal property, although you do have intellectual property rights that have to be addressed as well. What I don't know is, and I've never thought of it, and it's a great question, I believe there's no language in NAGPRA that talks about what happens to the repatriating museums documents and records of the object when the object is repatriated. Do you know, Shannon?
Well, so there's a two-part answer.
Okay.
So NAGPRA does provide for document access or document copying so that the tribal nation can research and better understand what the institution holds. So there is access available at the very least. And I think beyond that, I think you need to look to the National Museum of the American Indian, where they have a much stronger policy on documents and photographs and other types of items, because they aren't repatriatable items under NAGPRA. But the National Museum of the American Indian consults with tribes, and if there's items that are sensitive, if there are photographs, if there is information that should not be shared, that is censored and stored away from public access. And oftentimes it can be repatriated. So it's really about the will of the institution and how much they're willing to work with the indigenous nation on repatriating the full scope of that.
Can I just one quick thing, Jose? Just very fast, real fast. On images, there's a terrific chapter in Michael Brown's book, Who Owns Native Culture. First chapter of that book addresses photographs and audio recordings of Native Americans that were done in the end of the 19th, early 20th century, and I'd refer you to that chapter and its citations. The other is there was a lawsuit filed a week ago by the descendant of a slave as plaintiff against Harvard University, demanding return of images, photographs, that had been commissioned by Louis Agassiz of her ancestor on the theory that that Harvard cannot possibly have good title in a photograph that was taken of somebody without permission. It's going to be quite interesting to see how that lawsuit progresses.
Thank you so much. Thank you, everybody.
Thank you.